Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien rights. Today, we have part 7 out of 10, licensing considerations. No license, no lien in Tennessee, conducted by the fabulous Bryan Thomas. So without further ado, I would like to introduce the wonderful Bryan Thomas.
Well, as always, I appreciate that introduction. Hello to everyone out there. Been going a couple months now, so we are picking up a little bit further and into the details today about how the licensing law in Tennessee interacts with the lien law. It's an important consideration as we get into it, because if you are required to be licensed in Tennessee and you're not, you don't have lien rights. So it's something you got to understand when you're supplying everything from materials all the way up, and be careful who you're contracting with. So with that, we're going to start again. We've got the basics here for you. Make it interactive. You got questions, hit the raise your hand, send them along. I will endeavor to answer them as we go, or if you want to send something after the seminar, send it on over and we'll get an answer out to you. This is the agenda of where we are. We hope you've joined us in the past, and hope if you haven't, you can at least join us in the future. And that for those of you that have, hope you keep joining us as we move forward. So as we get started, just hitting the very basics again. So Tennessee lien law, pretty wide open. Who has them? The prime contractors and the remote contractors. The what work, pretty broad in what our definition of an improvement is, so long as something has been delivered to the property. The property we've talked about, we can lien the actual real estate, the fee estate, meaning the land itself, or if there's a lease on it and we contract with the lessee or lessor, we can get to their various interest in the lease. Again, in Tennessee, the lien is going to secure the entire contract amount. So all that's pretty helpful, gets us into the basics of where we are. From a timing perspective, again, this is very high level. If you want to see some of the details, you can go to our prior webinars, but at the high level, the prime contractor has 1 year to to file a lawsuit, but they have 90 days if they want to secure priority to get that notice of lien on file. For remote contractors, we've got 3 different steps. We've got the notice of non-payment, which is the rolling requirement that's got to go every 90 days. Notice of lien that's got to be recorded within 90 days of completion or abandonment. And then we've ultimately got the perfection with the attachment lawsuit. It's got to be 90 days after the notice of lien. Big picture, ran through that really quickly. Again, if you want to see some more details on that, go to our past webinars. For today, we've got to start with the licensing law in Tennessee. So I start you with the section of the Tennessee Code that deals with who is required to be licensed, okay? And what we see, I'm gonna do this pretty quickly, is it's anyone engaged in contracting or anyone offering to even engage in contracting. And the offering really gets a number of people, but generally, if we're talking on the lien side, we're talking about engaged in construction. Otherwise, we wouldn't really have a lien. Sorry, engaged in contracting. So that leaves the question of what is contracting in Tennessee? So we've got to go to the section in the Tennessee Code before. Contracting is very, very broad. And, you know, it's really it's pretty similar to the improvement definition. In fact, it includes the word improvement in its definition. I would also note that it includes installing any material. For those of you that are material suppliers and think of yourselves as material suppliers, but have a component of installation on site. That component of installation could get troubling from the licensing side. So it's any contractor in the state of Tennessee, and again, contracting is contractor. Contractor is anybody making any improvement to the property, including installing materials and equipment, where the entire construction undertaking is more than $25,000. Again, not necessarily an individual scope, more so as the project. How big is the project? So the 25,000 really catches most commercial jobs, unless it's something extremely small. The one caveat to all that is, well, let's talk about still what a contractor is defined as. A contractor includes really our MEP scopes. So if you're doing an install that requires mechanical and electrical work, then arguably you're gonna have to have a license regardless of if you are a prime or a sub. It also includes anybody out there that is performing as a construction manager, or even arguably, and this goes kind of a lot of different ways, an owner's representative that is performing within what that scope of a contractor was, that gets you up to contracting, that gets you up to what you're required to have a license for. So I just sort of say it this way. The definition of who has to be licensed is really broad. And if it is a commercial construction project, generally it's going to fall within the definition of contracting, because that's going to fall within the definition of contractor. So the big caveat, after I tell you all that, probably scared some of you, is that absent your MEPs, masons, and roofers, subcontractors don't have to be licensed, and subcontractors generally are thought of as remote contractors as defined throughout the Lien statutes. So most of the time, if you are a supplier or a subcontractor contracting with a licensed contractor in the state of Tennessee, and you're not performing an MEP, masonry or roofing scope, then you're probably okay without a license. But if you start getting into particularly those MEP scopes, you may have some problems with the licensing. My suggestion is, if you've got any install on the MEP side, go ahead and get licensed as a company. You're going to have a qualifying agent. You're going to have to go through some hoops. But if you're supplying of any magnitude and you're performing any really on-site work in that MEP scope, there's really a lot of risk on the non-payment side. Just to cover it, we've got first, no lien if you're not properly licensed, black letter law in Tennessee. So if we get to a court where, let's say, you've supplied some major piece of equipment that required some significant electrical work to tie it all in, and you don't get paid and need to lien the property, you've got some issues if somebody brings up a licensing violation, because the remedy for that licensing violation is you have no lien. Now, I also caution you as we talk about this, the whole seminar series is about liens and having liens or not having liens. But as we're talking licensing, I want to make sure that I give you a little bit more, because yes, it's true that if you're not licensed and required to be, you don't have a lien, but that's not the end of the story. We've got issues, and we talked about this section before. If you've essentially forfeited your lien because you weren't licensed and go ahead and file a lien and then refuse to remove it, you're potentially on the hook for attorney's fees for somebody, whether it's somebody above you in the chain, to go force and get the lien removed. On top of that, not being licensed is a violation of the Tennessee Consumer Protection Act, which gets you into even more hot water, opens you up to any actual damages, opens you up to treble damages, and also opens you up again to attorney's fees. And it doesn't stop there. We've got the statutory recovery. meaning that you're not going to be able to recover your contract amount at all if you're not licensed. Instead, you're going to have to go in and prove by clear and convincing evidence what expenses you can actually show. And your recovery is going to be limited to only those expenses. And that's a very high bar, much higher bar than you're typically required to get in civil litigation for a lien or otherwise. So, big picture, taking it from top to the bottom, our licensing law is really broad. That said, it excludes subcontractors unless you're performing MEP masonry or roofing. If you were required to have a license and don't have a license, you don't have a lien. On top of not having a lien, you're potentially exposed, if you do lien the property, to attorney's fees for somebody to remove it. On top of that, it's Tennessee Consumer Protection Act violation. And on top of that, your ability to get any money back is limited to the section that is in front of you. So that is all I have for today, but if there are any questions, I would be very happy to answer them.
Very nice job. At the moment, we do not have any questions, but if anyone thinks of a question after this webinar, feel free to send Bryan an email. I believe on the next slide, we have our contact details. Okay. So Bryan, our next webinar, maybe if you can go back to your contact details in case anyone has would like to reach out to you. Okay, great. And our next webinar is next month.
Let's be a little bit more exacting. Our next one is and we hope to see everyone there.
Wonderful. Well, thank you again. And I wish everyone a sunny day.
Thanks, Ariel. Thanks, everyone.
Thank you.